Hello, viewers. Welcome to the 78th episode of the Indian Lawyer Legal Tips. I am Somen Dash, an advocate with the firm, and today we are going to discuss on a very important topic which relates to legal aspects of export. To take this discussion ahead, we have with us Mrs. Sushila Ram Varma, an advocate and chief legal consultant at the firm, who is a seasoned legal professional. Last week, we had a one-day seminar organized by FIEO where ma'am was a keynote speaker on this very topic. So, ma'am, welcome to this session and thank you for agreeing to share your valuable insights on this very topic.
Thank you, Somain, and it's such a pleasure that we are recording our 78th episode. Thank you, team, for having brought us this far. So, Somain, let's begin.
And coming to the first question, what are the most common type of disputes that arise in international trade, especially for an Indian exporter?
Well, primarily, I would say it's always breach of contract. Now, of contract can be for n number of reasons. I would say most common would be that there are quality issues, or there is a delay in the timeline, or there are documentation errors, like there could be some error in the LC, or there could be some error in the escrow account, or the HS codes that have to be maintained are not maintained correctly. And then sometimes there are regulatory barriers that have to be considered. For instance, there are bans or some stricter norms in some of the countries that are introduced at the last minute. And invariably, it's always about the payment related issues. Like, for instance, if it's on a letter of credit, whether the terms are such that the letter of credit is enforceable or not. And also, many times there are geopolitical risks like what we are going through right now with India and US. This has caused a loss of billions of dollars to India when it comes to the export of certain products. Apart from that, even the currency fluctuation between India and the US dollar has affected us. And then there are logistic issues like delays because of the shipping congestion, and of course, delays because of the Russia Ukraine war and other similar political instability in different parts of the country.
Okay, ma'am. Ma'am, according to you, what are the essential clauses that every export contract should contain in order to minimize disputes and ensure smooth transactions?
Well, Sumin, we all know that at the end of the day, the payment is probably the most important aspect of any business. So I would say have very clear payment terms, whether it's an LC, whether it's advance payment, whether it's open account, or whether it's payment through an escrow account, whatever it is, make sure that it is very workable. And also ensure that there is a credit insurance when it comes to your payment terms, and read the credit insurance terms very carefully so that you get paid if anything goes wrong. Apart from that, there are certain aspects like delivery and performance terms. Be very careful about what you agree to, whether it's workable or not. Also, there are certain risk allocations like marine cargo insurance. Then you have the ECGC credit risk coverage, which is very important. And then you must also ensure that you limit your liability. Your liability should not be such that you are responsible for more than you took on. But all this can only be done if you get a lawyer to draft your contract and it is properly worded. And finally, I would say the dispute resolution mechanism is also something which is extremely important. So ensure that this is also done by a lawyer who understands cross border trades and cross border transactions like exports.
Ma'am, going to the next question, how important do you think is the choice of jurisdiction in international contracts and what best practices can help avoid conflicts to the maximum possible extent?
Well, in my opinion, jurisdiction is a very crucial area when you are looking at cross border businesses. Now, jurisdiction essentially means the choice of the place whose law you will agree to be governed by. So you have to be very clear on which law you will agree will govern the contract. Now, obviously, if you're an Indian exporter, you will say, I want the Indian laws. And if the other person, the importer is from US, he'll say, no, we want the US laws. But it's a possibility that both parties may not agree for various reasons. So you have to choose the law of a neutral country. Now, apart from choosing the governing law, there is something called seat, that is where the arbitration or the litigation will take place. And that also has to be thought out very carefully. in which country, because this is something that many people don't really bother, but ultimately they get into trouble. And probably the most important aspect of any decree or any award which is international in nature is the enforceability, whether or not it will be enforceable. Hence, I would say that you must take care of critical aspects like the predictability and certainty of the jurisdiction you're choosing, the neutrality of the arbitrators you're choosing, and most importantly, the enforceability, which is what one really looks at when one is looking at litigation or arbitration.
Ma'am, given the inevitability of disputes in global trade, what institutional mechanisms or alternate dispute resolution paths do you find most effective for Indian exporters?
Well, Somin, I have time and again told people don't go rushing for litigation and arbitration. Choose a 3 or 4 tier method. That is, first go for negotiation. Negotiation means I, as the Indian exporter, and say the US party as the importer, should negotiate with each other, sit across the table or do a video call, understand the urgency or the requirements of the other party, and try to resolve it. If it can't be resolved, then appoint a mediator. That should be the second layer of the of the 3 tier mechanism. That is, first negotiation, then mediation, in which a person who's a neutral party and who favors none, neither the importer nor the exporter, should sit and try to mediate the differences. Now, mediation is also non-binding. It's not as if a mediation has taken place, you're forced to accept it. And only after both fail, then go for arbitration or for litigation, depending on what you have agreed. So I would say be very careful before rushing into the final round, and do things very carefully.
Ma'am, with the rising importance of arbitration, what are the important clauses in an arbitration clause in an export agreement, and what details should it specify for effective dispute resolution?
Well, the first I would say is global enforceability. Whichever award is passed or whatever judgment is passed must be globally enforced. Otherwise, you're left with a paper decree and you have to restart the entire process. The second I would say is neutrality. You should choose arbitrators who will be neutral and not favor any particular person. So, invariably, what people do is they choose arbitrators from a neutral country, or they decide to go for litigation in a neutral country. Then you have institutions like ICC, LCIA, SIAC. These are all international institutes where arbitration can take place. And these are seasoned institutes where they are recognized for the fact that they know how to resolve cross border resolutions. Another very important aspect is you must remember that language is an extremely important aspect. Now, if you are exporting goods to Africa or say to China, and you don't agree on the language, what happens if you get a award that is passed in Chinese? You wouldn't understand. And then also remember that the arbitrators you choose must also be people with experience in cross border transactions. Otherwise, you will be left with a decree, or, I mean, sorry, with an award that will not be very easy to enforce. Okay.
And for a better understanding into this, can you please share your insights from landmark judgments like NTPC versus Singer and Balco versus Kaiser, and what lessons exporters can draw from these judgments?
Now, in NTPC versus Singer, it's a 1992 judgment passed by the Supreme Court of India Division Bench. In this, the parties had agreed that the contract would have an ICC arbitration clause. Now, when you say ICC arbitration clause, ICC has a standard clause. In fact, for that matter, all the other international institutes have a standard clause which people sometimes don't even reproduce. They just say we'll be bound by ICC arbitration. So they agreed to that, and the seat of arbitration was London. Now, when there was some issue, NTPC went running to the Supreme Court because it was an international arbitration, seeking some relief in the matter. But the Supreme Court declined because they felt that since parties had already agreed to a foreign jurisdiction as the seat of arbitration, there is nothing that they could do. Then eventually we had a judgment called Balco versus Kaiser, which is a 2012 judgment, and this was decided by a constitution bench of 5 judges. Now, in this particular case, there was an arbitration clause for London arbitration under the English laws. Again, Balco approached the Indian courts for interim relief. However, the courts felt that they could not pass any order when parties had agreed to international arbitration. However, recently, after the 2015 amendments, now Indian courts are giving relief under Section 9, which is the section of the Arbitration Act where interim relief can be given in an arbitration. And then the final relief is obviously given by the arbitrators wherever they are appointed.
Ma'am, according to you, what are some common documentation errors that can jeopardize export and how can exporters prevent them?
Now, I would say invoice discrepancies is one of the biggest things that like I said, incorrect documentation, incorrect description, incorrect valuation, that gets you into problem. HS code, which is used as a form of classification. If you have the wrong classification, again, you're in trouble with the customs. Then you have certificate issues, that is missing or incorrect quality certificates or export licenses. Again, you're in trouble. And then nowadays, most of these export orders are done digitally. So I would advise all clients download the form, fill it up manually, and then upload it, because one little mistake you made, you may have to pay a very heavy price. We dealt with a case in which the form had to be filled digitally, and where instead of writing yes, they wrote no, then they had to fight a litigation for years. So that's why it's always better that you do your documentation very meticulously. And the only way to do it is you download the forms, fill it up manually, and then again fill it up online.
And since trade is a very wide concept, what are the key professionals who form the backbone of a successful export business and how do they contribute to dispute prevention and resolution?
That surprisingly, exports require a lot of professional intervention and help. Since the list is very long, I am asking the editor to please list it out on the screen so that people can see for themselves which are the professionals, key professionals that are involved in any export business.
Okay, ma'am. As we reach the end of this session, I would now humbly request you to conclude this topic by summarizing your final insights.
Well, dear exporters and viewers, if you are looking at going into an export business, my first piece of advice to you, which is actually non legal, is be honest in your approach. I mean, you must supply goods that you have agreed to, that is, the classification, the quality, the quantity. Don't make these things come in the way. If you do not do things honestly, your goods are bound to be rejected, and then come what may, it is very difficult to be able to recover your money. Even if you have an insurance coverage, believe me, all aspects of the transaction are not covered, and it's a possibility that ECGC or the insurance company may say that since there were quality issues, we are not covering it. This is something that you were responsible for and you should have done.
Ma'am, it was a really wonderful session. We thank you from the bottom of our hearts for having enlightened our viewers by providing such crucial insight into such a key aspect related to international trade. Dear viewers, if you found this session useful and productive, we request you to please like and subscribe to our channel, The Indian Lawyer Legal Tips, and to share with as many people as possible. Please note that we at the Indian Lawyer and Allied Services are doing these video sessions as a social cause, and we intend that this knowledge be spread to the maximum number of people that is possible. Thank you very much for watching.